Good morning. Happy Wednesday. It's hump day, everybody. Get your hump on. Seb is the gift that keeps on giving, or at least he keeps on giving me talking points, so I'm enjoying it. Seb rejoined. First, he accused me of misinterpreting what he had to say, but of course, he was obviously too vague. He didn't give me a case name, he just gave me the number of justices on either side of the issue. But then he did give me the name, so I have the case name. Now remember, his original proposition is that ignorance of the law is no excuse for citizens, and that is based on them committing a crime. Ignorance of the elements of the crime is not an excuse. It doesn't allow them to commit the crime. But it is an excuse for officers, for the police. And to support this, now he's offering up Hein, H-E-I-E-N v. North Carolina. Hein v. North Carolina, surprisingly enough, it's not the cop who's on trial. It is somebody else who is on trial, I think for drug possession, smuggling, something like that. Cop sees a vehicle with one taillight out. Cop believes that the North Carolina vehicle code prohibits having a taillight out. Cop pulls him over, finds they're smuggling, I don't know, we'll say meth. It's North Carolina after all. So he bags him on the meth. The defense, the criminal defense, tries to get that evidence suppressed because the initial stop was based on an error of law. And the Supreme Court ends up holding, no, you can make reasonable mistakes of law, just like you can make reasonable mistakes of fact. The example they use for the reasonable mistake of fact is cop sees a woman driving in the high occupancy vehicle lane, doesn't see anybody else in the car, pulls her over, approaches the car, smells marijuana, assuming the marijuanas are illegal. Finds two sleeping kids in the back seat of the car. So she was not violating the high occupancy vehicle law, but he had a new independent probable cause to search the vehicle for the marijuanas. And you'll never know how many sticks of marijuanas he finds, how many injections of marijuanas, you never know. Anyway, which, number one, again, it doesn't justify Seb's initial position that cops are allowed to commit crimes and get away with it based on a ignorance of the law, justification, defense, or whatever. But it also allows us to discuss what is going on, what fundamental principle is operating. And it's the same kind of principle that will be saving furry potatoes bacon. I know a lot of people are thinking that because the DAs have declined to prosecute all of her private person's arrests, whatever you want to call it, citizens' arrests, that somehow that is evidence that she lacked probable cause to make the arrest. And probable cause doesn't mean that you know for a fact that there was a crime, and it doesn't mean you know for a fact that the person you're arresting committed the crime. That's not what the standard is. That's too high of a standard to know, to use like the reasonable doubt standard on both of those things. Because you just can't get all of the evidence and review it, etc., before making that arrest. Generally speaking, the feds do that a little bit more than most. Anyway, the standard for probable cause to make an arrest is that the officer believes it's more likely than not a crime was committed. And the officer believes that more likely than not, the suspect committed the crime. More likely than not, a crime was committed. That means that there is room. That's a skunk. No, you're not chasing the skunk. More likely than not means that there's room for error that a crime was not committed. It leaves room for error that the cop made a mistake of law. because you don't always know how the court's going to go. It also leaves room for error that you are the person who committed the crime. Now, in California, I've seen people talking about kidnapping and false imprisonment. In California, anyway, there is a statutory exception for arrests. If you're making an arrest, you're not kidnapping. It is literally, this does not apply to people who are making arrests, whether it's a private party, a private person, or a police officer. The kidnapping statute does not apply if someone's making an arrest. False imprisonment requires that the imprisonment be unlawful. And if there was probable cause, then it's not unlawful. It doesn't require the imprisonment. It requires the detainment, the restraint, or the confinement to be unlawful. So that's going to help protect Zoe, Furry Potato, and that also protects the cops. Because again, they're operating in that gray area. They have to operate in that gray area. And if they operate outside of that gray area, that's the only time that they're really going to be held liable civilly. Or if they commit a crime, obviously, they can get prosecuted. The guy who used the chokehold, they call it an illegal chokehold, but it was actually a chokehold that was against the policy of the police department. On, I think it was Eric Gardner. They tried to prosecute him like 3 or 4 times. Ignorance of the policy would be no excuse. Thanks for watching. Have a great morning.